This is our first book event that isn't a local Minnesota event. Both Jessica and I are writers in Minnesota. So Jessica could not make it out. She's actually doing a conference this weekend. We decided to split and tag team on events right now. But I'm really excited that you come out and learn more about the book. And just to give you a very, very brief kind of overview of what the book is about. Obviously, it's the 40th anniversary of Roe v. Wade. And because of Planned Parenthood versus Casey, which was a 1992 court decision that said that women still have access to abortion, but that it's up to the government to put any sort of restrictions on early first trimester abortions if they were seen for a woman's safety, as long as it didn't cause an undue burden on her access to an abortion. Ever since, in the last 20 years since 92, the states have been going through and trying to test out what exactly constitutes an undue burden, and they're stretching it to the furthest extent of the law. Because of this, we're seeing that we're ending up in a series of states that were in abortion and abortion-free states, where depending on which state you live in, how much money you have, what race you belong to, what your economic status is, you have a right to an abortion in name only. So we'll see states that have just one clinic and there are laws trying to close that one clinic so that there's no abortion whatsoever. We'll see states where there's no access to medication abortion and you can only have a surgical procedure. We'll see other states where you have these unlimited conscience clauses where basically anybody can call themselves a provider, cut off your access not just to abortion but to birth control too, as you're seeing happening right here in Michigan. And how each one of these states is in its own way coming up with this legal plan that will eventually take a case up to the Supreme Court that could give them a chance to overturn Roe v. Wade altogether. And even if they don't, in some states, having access to abortion is literally access in name only. And that's the overview of the book, and I'm just going to take questions because I think questions are probably a lot more what everybody's here to ask.
You want to kick it off, Todd?
Do I want to kick it off?
You look so comfy back there.
I'm very comfy. I would ask you to talk a little bit about the Conscience Clause and its movement across the U.S. and a little bit about potential impact, because it is being debated in Michigan. I think it's in the Michigan House now.
Yeah, and the Conscience Clause is actually one of two. There are, well, I guess three, it would be appropriate to say. There are three major model legislations that are being proposed by anti-choice groups in this legislative session. One is the idea of conscience clauses, one is the idea of trap laws, and one is the idea of medication abortion bans. And looking at conscience clauses, we first saw them really, really go into effect and really be debated in Kansas last year. Kansas had started this massive omnibus abortion bill where one of the parts of it was that anybody who was acting as a medical provider, and the key was medical provider, they didn't actually have to be a doctor, they didn't actually have to be a nurse, a physician, anybody who felt that they were in some way, shape, or form a medical provider could basically refuse to participate in any sort of event that they believe may constitute an abortion. And so this is a humongous stretching of what would normally be thought of as an abortion. One of the examples that we would see happen is that there was a prison guard who, a woman had come in for emergency contraception after she had been raped. She got the first pill of the emergency contraception. She went in to report her rapist, and there was a warrant outstanding for her arrest. So she was arrested. When she was taken in, they confiscated the other half of her drugs, and the woman who was in charge of her intake refused to give it to her because she said that she did not want to be participating in allowing somebody to have an abortion. Obviously, first of all, emergency contraception doesn't cause an abortion. Emergency contraception is what it is, contraception. It prevents ovulation. But because all the woman had to say was that she believed reasonably that she was causing an abortion, she was officially covered under Conscience Clause. And this is the sort of thing that you're going to be seeing if this bill ends up going through in Michigan, is that there's pretty much an unending, limitless thing to what you can call being a medical provider or what you can see as being involved in an abortion. In New Jersey, there was a group of 12 nurses who were they started a lawsuit because they were told that they were supposed to participate in abortion in the hospital that they were working at. For them, participating in abortion was if you had to do a medical record for a woman who had come in for an abortion, if you had to check her blood pressure after she had already had her DNC, if you even had to walk her out the door so that she could go and meet somebody at the outside of the hospital. And this was upheld, and they were found other jobs, and it falls under the conscience clause that anything can be seen as participating in abortion. One of the groups that you'll see that's really pushing these conscience clauses is a group called the Susan B. Anthony List. It's interesting because when the Susan B. Anthony List started originally, Marjorie, I never say her last name right, Meyer, it's one of those confusing last names. She used to be involved with National Right to Life Committee, and then she's over into this group that in essence said that it was existing to originally help elect pro-life women to office. They've kind of gone off that course over the last few years and over the last few elections, and really started to veer in 2010, where something really interesting happened as they got involved with candidates who were trying to fight against the Affordable Care Act. They actually started, I want to say Ohio, and I should have written this down. They started supporting candidates who were anti-choice men, Republicans, against pro-life female Democrats. And in doing so, what they said was that by saying that you supported the Affordable Care Act, despite the fact that we had the whole Stupak-Pitts Amendment and the Nelson Amendment and all these things in there to make sure that there's absolutely no way that there could be any commingling of abortion funds in the insurance exchange, that just by supporting the Affordable Care Act, you were in fact supporting abortion. The reason that this is such an interesting claim is because later in 2012, when Mitt Romney also said that he was okay with some of the aspects of the Affordable Care Act, they still supported him. And as you know, Mitt Romney has kind of a loose relationship with abortion. In some cases he would say that he's okay with abortion if there are exceptions for life of the mother, rape victims. At other times he would say, okay, he believes in abortion, he believes that life is a life at the point of conception. So he would go back and forth all through the election depending on who he was talking to. Throughout the whole thing, Susan B. Anthony List was very supportive of him and very supportive of his campaign. Yet when it came a time to, in the House races and the congressional races, pick the candidates that they were supporting, they would use the Affordable Care Act or any sort of support of abortion or even birth control as a reason to not support a candidate, if that candidate, of course, was a Democrat. So now we have hit 2012, and they began to do a series of these events across the country where they would support candidates who were the Religious Freedom Acts, so the conscience clauses in all of these different houses and senates, and basically everything that they could do to fight against the idea that employers had to pay for birth control or even pay for insurance that would cover birth control. One of the candidates that they were supporting was Wendy Long in the New York Senate race, and she was running against Kirsten Gillibrand. And Wendy Long went out of her way to oppose abortion, oppose contraception, and she was one of the pro-life from the moment of conception to the moment of natural death candidates. So the Susan B. Anthony List became very involved in all of these religious freedom acts that were happening all over the country, and has gotten to the point where they're starting to write model legislation on that sort of thing. So that's why you're seeing all of these conscience clauses popping up everywhere, and they have come up mainly in reaction to the idea that employers are going to be paying for birth control. It's another way of opposing the Affordable Care Act, and it's also another way of helping to battle the idea that emergency contraception could be available, especially over the counter. That is terrifying to them. So that's why you're seeing conscience clauses happening in so many of the states, because they can't actually go out and say, okay, we're going to oppose birth control, but they can go and try and make a legislative manipulation to make sure that other people can block off that birth control for you.
I was actually just going to do a follow-up on that.
Follow me.
In terms of Michigan's conscience clause, the Republicans that are pushing it are actually pointing towards the case of Julia Ward, who was dismissed from Eastern Michigan University for refusing to counsel a homosexual.
Yeah.
And we've already passed a counseling one, so counselors are already protected. But what is the relationship, and what relationship do you see with these conscience clauses, not only in trying to impact choice, but also LGBT people and their access to health care?
Well, and it's not even just that. I mean, conscience clauses are, in essence, a way of saying we need to be able to opt out of anything that we do not feel follows into our biblical principles. It's whether it's a conscience clause to say, okay, my kid should not be taught this in school. It's a conscience clause to say, okay, I should not have to provide flowers for this gay couple's wedding. What we're seeing is that conscience clauses are popping up all over in states at the same time that you see groups like the Alliance Defending Life, the Alliance Defense League, the Liberty Council, all of these groups that are doing these a lot of people, I think, are ridiculous lawsuits that are a means of protecting freedom of speech. And so we're going to hit over and over this idea of what doesn't fall under religious freedom, because that's what all of these cases are to test out. And it's either testing them out in schools, it's testing them out in doctors' offices, it's testing them out in counseling centers. But in the end, it's an idea that lawsuits on one hand will help cripple any institute that they're doing a lawsuit against. So for instance, this new example that just happened in Minnesota right now is that there is a lawsuit that is being done by Alliance Defending Liberty something or other.
Alliance Defending Freedom.
Yeah,
Used to be the Alliance Defense Fund.
Yeah, they keep changing their names on me, and that makes it really hard to write about. But it's to protect a 6th grader who was not allowed to pass out anti-choice literature in her classroom, and it's a public charter school. So on the one hand, you have a legal defense that, okay, based on her freedom of speech, she should be able to pass out whatever she wants at a school. By a group of people that, quite frankly, don't like public education in the first place. So you have people going into the public school system, trying to convert it into supporting their own views, and then when it won't do that because it is a public school system, suing them, knowing that it will deplete a school's funds, and then there might not be as much public school system. So in a lot of ways, it's kind of a roundabout sue it until it dies sort of situation, and these conscience clauses are happening in states so that there's more avenues open in order to do lawsuits and use that as a means of breaking the system. And something that I found really interesting that you wouldn't think relates, but when you think about it, it really does, is the idea that Operation Rescue is now a legitimate group. And by legitimate group, does everybody know Operation Rescue and the history of, like, in the 80s, blocking clinics and trying to chain themselves to machines and all of that to try and make it so that women couldn't get abortions. They schismed over time. FACE Act kind of broke them down a little bit. But one of the things that Troy Newman, who is running Operation Rescue now and took over after like 5 different presidents as they were going through their different mechanisms, said is that they no longer are doing protests. They leave protests to other groups. What they do is they're looking for governmental ways to shut down clinics. So Operation Rescue tries to shut down clinics through contacting health departments and saying, I think that such and such is wrong with this clinic, by doing freedom of request acts and getting enormous amounts of information and then culling through information, trying to find ways that they can shut down clinics that way. Troy Newman, when talking about the new Wichita clinic that has opened back up, which was the clinic where George Tiller was shot, said that they are not going to be protesting the clinic. They have alternate means of trying to close clinics now, and this is their way. They're using their own bureaucracy to try and close down clinics. But this is a group that doesn't believe in the government. So you have all these groups that are limited government and anti-government and such, but they use the trappings of bureaucracy in order to try and get what it is that they want. But then they say that they're anti-government oversight and they don't want government involved in their lives. yet they're using the government in order to try and create the means that they want in order to create the kind of country that they want. So it's all kind of this roundabout, use the things that you say that you hate in order to get the things that you want.
I mean, you kind of touched on it there. One thing I'm having trouble with lately, over the last couple of years, in terms of trying to create, and this crosses over, this is the
It all
same
crosses
as true
over.
with GMOs and health issues like that, that there's so many groups that pop up and they hide themselves. Like, you may have saw recently, there was talk about the Eden soy
Yep.
family group trying to block health or birth control to their, and they're supposed to be a very, you know, progressive hippy dippy company.
Yeah.
How is there a way for the average person to sift through?
No.
Okay. Post something
No.
and then, you know, 20 people go, oh my gosh, and then one person will pop up and say, oh, by the way, that group is related to this group, or, and I, you know.
And it's terrifying because there isn't a mechanism. In some ways, I mean, the internet is the best thing in the world for that because it has a way of networking so many people with so many different understandings. But, I mean, if you go through just anti-choice groups, for one thing, you'll see that, I mean, today I read an article from Color Lines about crisis pregnancy centers and a new form of trying to open pregnancy centers for women of color in St. Louis that was really fascinating. But as an aside, going through all of the history of crisis pregnancy centers and going through the idea of the Black genocide and such, she referenced 3 different groups that I thought were 3 separate groups, but apparently were actually 3 different names all for the same group, which I had no idea. But it's just every time they did a different billboard campaign, they would call themselves something else, and I didn't know they were all Ryan Bombarder. And I'm like, well, that's interesting. Why aren't we tracking this? And it's because we can't, for one thing, because there's just so much. It's like the idea of you have your internet troll, if you will. Think of them as internet trolls. So you have your internet troll, and you're like, man, this guy's a jerk. And you know what? This guy's a jerk too. And this guy's a jerk too. And then eventually realize that this is just 5 different iterations of the same jerk. So it's a matter of trying to catch it all is a full-time job in its own. So yeah, you just basically have to put out information constantly and always be on the guard. And especially, like, we've seen, like, from the Koch brothers and all of that, that there's an invested group of people who their job is to muddy the waters. And they'll set up a think tank and then put out fake science and such and so forth. And it's muddying waters for a really purposeful reason. Like, for instance, one of the new groups that has come out in the last, I want to say the last year, is a group called the Lozier Institute. The Lozier Institute exists basically as a counterbalance to the Guttmacher Institute. Guttmacher Institute has been claimed for decades now to be this right and left-wing arm of Planned Parenthood, and so their stats can't be believed. In order to counter this obvious left-wing arm of Planned Parenthood, they have started the Charlotte Lozier Institute. The Charlotte Lozier Institute is an offshoot of Susan B. Anthony List. If you get nothing else from tonight, is that I have huge issues with Susan B. Anthony List. And of the Charlotte Lozier Institute, what they do is they present their pro-life facts and their pro-life science. And their pro-life science comes from 2 sources, basically. One is Guttmacher Institute, because they are facts, and then just sort of rearranged and manipulated and take out the information that they want to use that works for their side, because facts don't really have a bias. And the other is David Reardon and Priscilla Coleman. And they are the 2 members of the Elliott Institute, which, if you have ever read anything that says that abortion is going to make you want to kill yourself, or abortion causes breast cancer, or abortion makes you infertile, or all of these women say that they regret their abortion, all of it came from the Elliott Institute. And it all came from a 75-person study that David Reardon did back in 1982. So, I mean, it's not a huge batch of evidence. This was a self-selected study of women who came in for counseling for him afterwards when they had abortions, and then they were upset about it. But everything will all come back to, you'll see David Reardon or Priscilla Coleman on it. The problem with this is because they now have this institute that has published this information, we have what the courts are considering non-conclusive medical evidence. So what we saw in South Dakota, and you'll see in the South Dakota chapter, is that when the court is faced with what they see as non-conclusive medical evidence, so the entire medical community says that a fetus can't feel pain at 20 weeks. However, these 5 pro-life doctors say it can. Oops, we don't have a consensus. So, since we don't have a consensus, lawmakers get to decide which one they're going to believe. And that's what happened in South Dakota. With South Dakota, they had a law that they litigated for about 2 years that basically said that part of the script when a woman goes in to have an abortion is that she has to be told that abortion will end a complete and unique individual life. And it's the first informed consent bill that says that abortion may make you want to kill yourself. And the study, of course, came from Priscilla Coleman, and it was published in, I want to say it was published in JAMA, but then they went back and realized that nobody could replicate the evidence again, so they decided that they were going to pull it. But that science was already out there, so when the federal courts looked at it, they said, okay, we don't have a scientific consensus, so yes, we're going to let this law stay. So now every woman in South Dakota, when she goes to get an abortion, gets to hear that she's going to want to kill herself afterwards. Which, of course, no doctor's going to say, well, you know, frankly, if you have a pregnancy that you don't want to continue with and you're forced to give birth, that's probably going to not make you very happy either. But medical consensus doesn't agree, so the legislature gets to decide what the woman is going to hear.
Can't the courts go with the preponderance of evidence?
No, they cannot. You would think they could, but they
Climate
cannot.
change. There are 2 guys out there that don't believe it, you know?
And that's exactly why they do that. And that's why they put up these institutes, these fake institutes that say, okay, here's this scientific evidence that we bought and paid for that says that climate change doesn't exist because we did this 2-month-long study. And now all of a sudden you have fake evidence, and the courts get to say, legislators, you decide, because we can't decide from the bench because that would be legislating from the bench.
It's so Machiavellian. It makes my skin crawl. Like it's bullying.
Well,
it's bullying.
and
That's
it's
the other thing that I find so offensive with like the transvaginal probe thing, and it's straight up bullying.
It's straight up bullying. It's straight up bullying. I try to say with a conscience. One of the things that I've realized from having read a ridiculous amount of early history in the movement is the fact that almost every abortion restriction that we see these days are written by people who are still trapped in the 70s. And they're written by people who, either because they had their abortions in the 70s or they went through talking to people who had abortions in the 70s and haven't moved on, they still have this 70s experience of how abortion happens. And they still think that it's this really invasive medical procedure, which it doesn't necessarily have to be. They think that it's very unsafe, which we've seen studies and there aren't that many complications. And they think that it's this, they don't understand that most women will have an ultrasound before it happens. There's a difference between, okay, I'm going to probe you now and you don't have any choice in it, and okay, we just need to check and see and make sure that there's gestational sac. It's a difference in how it's given to a woman. Most women in the 70s, when they showed up for an abortion, they didn't know for sure if they were pregnant until they actually got there and took a pregnancy test, because pregnancy tests weren't as easily available or as cheap or frankly as good at the time. So things that we look at now, so a 24-hour wait period. At that time, that did make sense because a woman would go in, she would find out that she was pregnant, and then somebody would say, okay, let's have an abortion while you're here. That doesn't happen today. Women who go in for abortions aren't wondering if they're actually pregnant. So they've already made the decision before they got there. Counseling happens. Clinics counsel women before they have abortions. If any of you have seen the live action video that has just come out, the big expose of infanticide that's happening all over the country, because this is the sort of thing that I do, I actually sat through the entire 2 hours of unedited video of the original Bronx investigation, and it's 2 hours of video. Frankly, there's a ridiculous clinician intake person who is doing most of the talking and obviously has no idea what she's talking about and very obviously has never actually sat through a procedure. And then that's not the person who actually provides the access, as it were, to an abortion. Before the woman actually gets the abortion and starts the procedure, she then talks to a counselor. They used maybe 30 seconds of her actual talk with the counselor. She was in there for a good 10 minutes. And the end of the video shows the counselor asking her, you know, you knew weeks ago that you were pregnant. You've only now decided that you want to have an abortion. What has changed? Have things changed in your life that have made you decide that you want an abortion now? Are there ways that we could address these issues so that we could maybe do this without an abortion? Is there something that we could do that might make you want to continue the pregnancy? And the woman's very obviously taken aback by this, and she's like, you know, no, nothing's changed. I don't really want to talk about this. No, everything's still the way it is. And the counselor says, you know, you said you came with a friend. I think that you should go and talk to your friend for a while. Go talk to your friend. If this is still something you want, then come back and we'll go ahead with it. The counselor counsels her out of her abortion. The counselor says, you need to go think about this longer. That is not something that they are going to show you on a video. Every woman goes through this intake, every woman talks to somebody, and every woman has a chance to make sure that this is definitely the decision that she wants to make. These are the things that they don't know because they're still stuck in the 70s and the early 80s in this idea of the abortion profiteers that was the expose that they ran in the Sun-Times in Chicago in the early 80s. This is not what today's clinics are like, and they're still living in these olden days.
You mentioned the 1992 decision, Planned Parenthood versus Casey.
Yeah.
Which I don't think most people realize how close we came to Roe v. Wade being overturned. And we only found out 5 or 6 years ago from Harry Blackman's papers that the original vote was 5-4 to overturn Roe. Mm-hmm. And Justice Kennedy changed his vote. He was originally going to write the decision overturning it, and then Souter and O'Connor essentially talked him out of it.
Which is why, since then, every single law has been geared to Justice Kennedy.
Yes.
So, we'll talk a little bit about Planned Parenthood versus Casey. Planned Parenthood versus Casey. This was a Pennsylvania court case that worked its way up to the Supreme Court, where Pennsylvania basically did one of the first massive anti-abortion omnibus bills. And the idea was parental consent, mandatory ultrasound, mandatory counseling, mandatory this, that, and the other. I think if I remember right, it was a 3-day waiting period. And back then that was a really huge deal because there weren't really waiting periods at all. Now, unfortunately, we're seeing 3-day waiting periods. But the thing that actually managed to make them not, that made them challenge the law, and the part that made Kennedy turn on it, was spousal consent. And the idea that you could not get an abortion if you were married unless your husband agreed to it, and it was shown in writing. And spousal consent is coming back, just so you all understand. I don't know when it's going to happen. I do know that there are states that it's in the background of. I actually talked to a representative in Missouri who told me that he saw the bill, but that he wasn't going to be the one to propose it, even though, God, if anybody was going to propose it in Missouri, it would be this man. Because he was doing his own mandatory ultrasound bill that he saw was a form of spousal consent because you had to take the stuff back to your husband and talk to him about it, or that's how he envisioned it working. So spousal consent was the one thing that Kennedy felt went too far and was the reason why he decided that he was not going to, that all of the laws were going to stay in place. And what they did then was set up this dichotomy that previously, because of Roe, abortion was unlimited and with basically no restriction until the point of viability. And then at the point of viability, that was when they felt that the government had enough interest in potential human life to start to put rules. So if it was going to endanger the woman's life, if it was going to put her health at serious risk. Those were the things that had to be weighed out, and the further along that you were in your pregnancy after that, the more rules came into effect. With Planned Parenthood versus Casey, the idea was that it's a very condescending ruling, frankly, because it says that women aren't necessarily that smart. And so because abortion is in itself a medical procedure that has its own heightened risks, that abortion in the first trimester could have certain restrictions on it, as long as those restrictions did not cause an undue burden to the woman, and these restrictions all needed to be presented in a form of ensuring that a woman's safety was paramount. So, be it mental health safety, which is why they introduced the ideas of informed consent since then, because a woman might not know all of the different things that are happening. She might not understand that having an abortion means that you're terminating an actual life, that pregnancy is too euphemistic, so you need to understand that there's an actual thing in there, that even though like 1 out of every 3 women who has an abortion is already a parent. And you know, if informed consent really were about making sure that women understood what was going on inside of them, there would be an opt-out for women who have already had kids. Because obviously, you know what a baby is. Figured it out. So every law since then has been about posing it as a woman's health or mental health is somehow at risk by abortion, and these are ways to make sure that that health is taken care of. That's why trap laws have become so popular in the last couple of years. And a trap law is a targeted regulation of abortion provider. It's basically saying that as a medical procedure, abortion is being treated separately than any other medical procedure. So, for instance, the trap law that is the most popular right now is the idea of anybody who provides an abortion has to be a board-certified OBGYN. And that board-certified OBGYN has to have admitting privileges to a local hospital. It's crap. It's crap for a lot of reasons. Perhaps one of the best ones was what one physician told me, which is, you know, she's an OBGYN. If she, say, accidentally perforated somebody's uterus doing an abortion, the last thing they would want is for her to be the person who would go in and do any sort of fixing. They would want somebody else to do it. Because you should have somebody who specializes in that type of surgery, or you should have a person that isn't involved with the patient because maybe you've already possibly caused this mistake. You don't want to be involved in this part of the care. They would want somebody else to come in and do it. It would basically be the equivalent of saying, okay, you're going to give birth, that's great. You can't use your general physician. We think that you are possibly going to be in danger, so we're going to make sure that just in case you do need a C-section down the road, you have a surgical OB. If we had rules like that, people would be aghast. People would be aghast at the idea that the only person who could help you deliver a baby would be a surgical OBGYN who can perform a C-section in case something goes wrong. That's not what you do. You have the baby, and if something goes wrong, they'll bring somebody in who's going to take care of you when that happens. The first really trap has been happening for a while, especially the admitting privileges. It's happened in a lot of different states, but it came to the foreground in Mississippi because Mississippi was the first time that they've ever tried it in a state that only has one clinic. And by only having one clinic, and by abortion becoming so highly politicized in that state, they knew when they passed the law that there was no hospital that was going to give admitting privileges to these doctors. I want to say before, it might have been about the same time, but the idea of making sure that the doctor who provides the abortion can transfer a woman into a hospital and then deal with any sort of possible effects if there's an issue is kind of inadvertently sponsored by Phyllis Schlafly, of all people. And what it is really the most extreme version of the idea of no taxpayer funding for abortion. What she proposed was that The reason that doctors need admitting privileges is because if a woman is harmed in an abortion and has to go to a hospital, then the hospital is in essence footing the bill for that woman being taken care of. If a doctor spends any time, if it uses any hospital resources in any way, shape, or form, and that hospital might be getting some sort of money in some way, shape, or form from the taxpayer, then inadvertently that's a taxpayer funding and subsidizing of abortion. So that's really just the most extreme way that you can go with the idea of no taxpayer funding for abortion. And we've seen crazy extremes when it comes to no taxpayer funding for abortion. So that's not really surprising. But in Mississippi, because Phil Bryant had said over and over again that, you know, this is really about trying to close the clinic, that's how they ended up suing it. And Center for Reproductive Rights is still working on the case, and they managed to get it so that the clinic itself, the doctors are not punished for not following the law. Which is kind of this cop-out that the judge underwent, so that he never actually said that it was an undue burden under Planned Parenthood KC, because that would set up a precedent that would allow other clinics to then challenge and say, okay, well, then if it's not necessary in this case, or it's an undue burden in this case, then why do our doctors have to have admitting privileges? And Tennessee, Indiana, there are a bunch of other states that have these same admitting privileges rules. It's just in those cases, it's not an undue burden because it's not going to close down the only clinic in the state. So what we say is that the judge basically punted on the whole issue and then just left it up to the state to then do all of the maturations that were necessary in order to try and close the clinic. And they tried to close the clinic and pulled its license and did its review. And it was 3 weeks ago, I think, that they finally officially gave the paperwork that the clinic was closing, and only then did the judge step in and say, okay, well, obviously I'm going to have to block this order right now because you're not going to close the only clinic in the state of Mississippi.